And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you tonight, talk about some solutions that come in different words. So we're going to talk about give unto Caesar what belongs to Caesar and give unto God what belongs to God, as to differentiate the words so we can see the solution in all of the different ways that they state them. And I'm trying to look up something here. Let me get it here real quick. In regards to the UCC, okay, bring that over here. And of course, the link is down there for anybody that wants to join the panel. There's PayPal link down below in the details section for anybody that wants to share some love. And be sure to hit the like, share, and subscribe button. And we're going to take a look at UCC 1-103. And as we see, it says, construction of Uniform Commercial Code to promote its purposes and policies, applicability of supplemental principles of law. The first one here tells us the Uniform Commercial Code must be liberally construed and applied to promote its underlying purposes and policies, which are to simplify, clarify, and modernize the law governing commercial transactions. Governing commercial transactions. Supplemental principles of law is what governs the commercial transactions. Everything must be done in good faith. That is a principle of law. To permit the continued expansion of commercial practices through custom, a supplemental principle of law. Usage, a supplemental principle of law. And agreement of parties, supplemental principle of law. This is listed in the public forum as a contracting term for public contracts. The supplemental principle of law of contract, though, is privacy. That's the agreement of the parties. And to make uniform the law among the various jurisdictions. Commercial law is one of the lowest jurisdictions when it comes, or commercial transactions, when it comes to any kind of various jurisdiction. And its supplemental principle is the primary source, the primary investment, the primary credit. So when it says the law among the, or to make uniform the law among the various jurisdictions, if there is something in a lower jurisdiction that doesn't give you the benefit or greater benefit of something supplemental to a greater jurisdiction, then it should be amended. All of these laws, even the supplemental principles of law, come from the scriptures. That's where the principles lie. The next one we're going to talk about in relations to those um, instruments, the commercial transactions, the instrumentalities of commerce, whether they be by a government body, a political body, a religious body, a private association body, whatever, comes to that signature. And he saith unto them, this is Matthew 22, verses 20 through 21. And it says, and he saith unto them, whose is this image and superscription? They say unto him, Caesar's. Then saith he unto them, render, therefore, unto Caesar the things which are Caesar's. Render is the action before you tender it. When you get an instrument, an application of some sort, or registration, they ask you to put some things on there. That's what you render. And if you don't render it correctly and don't make a distinction between Caesar and God, there's not going to be that distinction. It's going to be one-sided. That's the unilateral agreement. Wherein to permit the continued expansion of commercial practices and agreement of the parties imports a plural and a singular. So you have to pay attention to the terms they use of the party. The party is synonymous in their code under 1 U.S.C. 1. The singular imports the plural, and the plural imports the singular. And that's a specific term, import, as it relates to export and support. Okay? The commercial law has no support unless somebody exports something so that it can be imported into the commercial system. It has to come from somewhere else, supplemental to it. Unless displaced by the particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplements its provision. So, applicability of supplemental principles of law as it relates to the principles of law and equity. The equity is what comes from the scripture. It's what's in your heart as being fair and righteous. I don't know how we lost screen share. Unless displaced by the particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract. And this is qualified by a signature. If you don't place the proper qualification, it's going to be presumed by the signature alone that you have the capacity to contract, and therefore you are in the capacity of contracting as either a principal or agent, one of the agreeing parties. Principal as it relates to the primary investor, primary creditor, who then extends credit to an agent to conduct a transfer. and other validating or invalidating cause supplements its provisions. The invalidating cause would be an inconsistence with the law or an impossibility. The inconsistency meaning you have to go back to a point where it is consistent and try to make it continuing inconsistent or with consistency there. If that is not possible, then it's an impossibility, and now you don't have the capacity to contract. It's not a valid contract for validated or invalidated causes. I hope everybody got that. So the next one is 2 Kings 20, verse 1. In those days was Hezekiah sick unto death. This is the spell of illness that creates the person. Okay? And there is no living will. And the prophet Isaiah, the son of Amoz, came to him and said unto him, Thus saith the Lord, set thine house in order, for thou shalt die and not live. Thus saith the Lord, set thine house in order, as it relates to, if you want equity, you must first bring equity. So when they give you a document from their house, you let them know where the credit for that house even comes from, and that you are a mere pass-through, and that you live, and that the pass-through that is being, or the thing that's being passed through is the credit, and it's done in person. In person. It has a name. The next one is that 3-402 of the UCC that I talk about, the signature by representative. And that's that American citizen versus United States citizen. And again, when we look at, in those days was Hezekiah sick unto death, that was the creation of the United States person, the United States citizen. And no one created a living will and stated that I live. I am the American citizen, and it is to my credence that that person was created, and it's to his credence that I was created. So no matter how you want to look at me, is if you use the term primary creditor or primary investor, the original investment was the full armor of God, and that's what I'm posing here. This is a beast system. It's a Goliath. You can call me David. I don't need the armor of the United States. I'll stand in the full armor of God as I was meant to, a prophet unto the nations. So let's look at this signature one again. As it relates to those little words, in and on. We are not of this world, we are in this world. So what is the credit of that is named in the document that we sign on? Signature by representative. If a person, now I want to remind you, as person is defined, is a fiction. Now the closest they can get is a natural person, but that is not the term they use here. The term person here indicates a singular, but again, a singular imports a plural, so it can mean any person, including a natural person and any other type of person, which would be a corporation, trust, sole proprietorship, LLC, da-da-da-da. Okay, anything using those commercial instruments. Acting or purporting, just like supporting, importing, exporting, it's purporting. To act as a representative signs an instrument by signing either the name of the represented person or the name of the signer. The represented person is bound by the signature to the same extent the represented person, or the name of the signer as a representative as opposed to the represented person. Represented person. Represented person. Represented person is bound. The signature of the representative is the authorized signature of the represented person, and the person is liable on the instrument whether or not identified in the instrument. So if you read between the lines and you understand trust law, if I am a principal and I give a directive to a trustee to handle the instrumentation and sign on my behalf, he would sign trustee and then give a signature. And that would be a qualified signature of a representative for the signature. He's accepting liability in that capacity. Without putting trustee on there, you are still presumed to be trustee because you didn't qualify it, and that's a blank endorsement, and they will assume the trustee for as your capacity and presume that they are the beneficiary. The trustee is so named by the signature, and if you don't qualify it in the proper capacity, then it's going to be presumed, and all of the documentation is going to be treated as if though issued by a trustee and not the principal, and that would be an agent. A trustee is an agent. The principal is the one that gives the directive. That gives a directive. If a representative signs the name of the representative to an instrument, and the signature is an authorized signature of the represented person, the following rules apply. If the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable on the instrument. But if you sign that name and it's the same name as the person in there and you don't qualify it as a representative signing on behalf of it, then you're going to take on that liability because it was ambiguous. You didn't clarify it. So if the form of the signature shows unambiguously that the signature is made on behalf of the representative, such as by benefactor, then it's going to be presumed that you're signing in capacity of the agent who is identified in the instrument. That the signature is made on behalf of the represented person who is identified in the instrument. The representative is not liable on the instrument. So with the proper assignment of a trustee making a signature on an instrument on your behalf as the represented person is an indemnification saying the representative is not liable on the instrument. So if you come forth in those days was Hezekiah sick unto death, and give them the prophet Isaiah, son of Amoz, came to him and said unto him, Thus saith the Lord, set thine house in order. This instrument is not used for debt, but for circulation. Things that are dead have no circulation, and that's part of the problem. The things that we're signing are going out into a system, and it's a dead end and it never returns back because there was no living will. When you attach the living will, now it can go back to its source of credit. And it's a hard thing to do that at the end of life. Particularly much easier if you start doing that during your life. My yea is my yea, my nay be my nay. Subject to subsection C. If 1, the form of the signature does not show unambiguously that the signature is made in a representative capacity, or 2, the represented person is not identified in the instrument, the representative is liable on the instrument to a holder in due course that took the instrument without notice that the representative was not intended to be liable on the instrument. Without prejudice, without recourse. You're dismissing the liability. In so doing that and qualifying that signature, the trustee that is signing is also the representative, is not liable on the instrument. It's an equal consideration, bringing it to a private recognition of the private data elements that need to be, confidential. With respect to any other person, the representative is liable on the instrument unless the representative proves that the original parties did not intend the representative to be liable on the instrument. So just knowing the proper capacity would prove that you didn't have the intent. If you didn't know the proper capacity, then it's not likely anybody can prove intent. So all you got to do is, I'm sorry, had I known that would have been the effect, I would have never signed in such capacity. If I'd have known that I was taking on these liabilities that placed me as an officer in the public trust in capacity of a defendant or plaintiff that is suited for employment to do such things, I'd have certainly studied up on that and made sure that I was qualified to do so. However, now that I've come to discover that I'm not qualified in such capacity and have learned how to qualify that signature, I must rescind those so I can qualify them in the proper true capacity that I was in fact in, because the record never shows any emoluments for performing the functions of public office anywhere. And I want to take a minute to remind everybody the like, share, and subscribe button's there for anybody that wants to hit the button. And of course, there's PayPal link down below for anybody that wants to share some love. StreamYard link coming up again for anybody that wants to join the panel. Always appreciate some company. And what I'm talking about tonight is coming to a solution that can be affected through various different ways. Yeah, you can go out and get a job and use that identification system and get money to go out and buy a piece of property. But again, that's the same thing as using gold to exchange for property. It's prefaced on the fact that you're trying to buy land. That's a false premise. If you're going to possess the land, you have to give credit where credit is due. We'll talk about that more later. But first, we're going to move on to 31 CFR 328.5, Forms of Endorsement. Forms of endorsement. And remember, folks, there are things that, again, it's uniform throughout all jurisdictions. So they can say the same thing, but they use different words. We can do the same thing with our forms of endorsement. We can change the wording around a little bit to give a little bit more clearer directive or more supplemental definition. When presented by banks for payment or exchange, the endorsement placed on a bearer security. That's somebody that's bearing a security. That's the holder in due course. And if you don't have a qualified signature on there, anybody that gets that their hands on that instrument can make a qualified endorsement. Presented for payment or exchange by a bank should be in the following form. For presentation, not representation, but presentation to the Federal Reserve Bank of such and such fiscal agent of the United States for redemption or in exchange for securities of a new issue in accordance with written instructions submitted by, and then insert name of presenting bank. Or you can do for redemption at par, the endorsement placed on a bearer security presented for redemption at par in payment of federal state taxes should be in the following form. For presentation to the Federal Reserve Bank of fiscal agent of the United States for redemption at par in payment of federal estate taxes in accordance with the written instructions submitted by, insert the name of presenting bank. For conversion to book entry securities. For conversion to book entry securities, the endorsement placed on a bearer security presented for conversion to a book entry security shall be in the following form. For presentation to the Federal Reserve Bank, fiscal agent of the United States, for conversion to book entry securities by, insert name of presenting bank. When presented to service center directors or district directors, Internal Revenue Service. The presentation to the Federal Reserve Bank of such and such fiscal agent of the United States for redemption, the proceeds to be credited to the account of the Service Center Director, Internal Revenue Service, at such and such for credit on the federal income, gifts, or other taxes due from name and address. Okay? This is going to be like wording. This is from rubberstampchamp.com, knockout price and service. And they make rubber stamps. And this is the one we're currently using right here in the top left-hand corner. And they have several versions. But this top one you don't see in there. For presentation to the United States Treasury for redemption or in exchange for securities of a new issue. So the redemption is something that was an old issue, because you can do or, which is like wording, in exchange for securities of a new issue. So if there's an old issue, which is a polar opposite, it's an opposing dynamic. Opposing dynamic, Paul likes to use that one a lot. This is an opposing dynamic to the ones that they just put in the code. For presentation to the United States Treasury for redemption or in exchange for securities of a new issue in accordance with the written instructions submitted by. And you don't put your name up there. That's going to be the presenting bank that's going to submit them with written instructions submitted by. So you're going to give them written instructions. You're going to clarify, listen, buddy, I'm the principal, you're the agent. Okay? You're going to do that without using those terms. Oops, I forgot to change my screen there. For presentation to the United States Treasury for redemption or in exchange for securities of a new issue in accordance with written instructions submitted by. Got a Saturday morning group. This is the second version. For presentation to the Federal Reserve Bank of, fiscal agent of, the United States for redemption or in exchange of, for securities of a new issue in accordance with written instructions submitted by, and then they put the presenting bank. And when we're doing all this stuff, you see me on this internet and everybody likes to use these devices to see who's broadcasting out to the general public. A wide open audience. Wide open audience. And here's where I want to remind everybody once again, please hit that like, share, and subscribe button. It always does help for people that are interested in this information. But if you're subscribed to this channel and you don't really have an interest in this information and you're really not going to be active on it, then go ahead and unsubscribe. I don't care if you give me likes or not, because this isn't for you. I'm not interested in numbers. I'm interested in people that are interested in the actual message of the information that's being put out. Again, if it's uniform throughout all jurisdictions, then put on the full armor of God and make sure that word is the one that trickles down. It's uniform all the way through and through. So instead of broadcasting, we're going to be talking about narrowcasting, and I've done videos on this before. Narrowcasting is the basis of the reconciling of a master trust account. Handbook F101, I did a series of 43 videos on this, reconciling master trust accounts at Postal One sites. Effective immediately, Handbook F01, Field Accounting Procedures, is reviewed with new procedure for reconciling master trust accounts for Postal One registered sites. Postal retail units that are interfaced with Postal One are no longer required to reconcile master trust accounts once a month. Instead, these sites will receive a narrowcast master trust exception report when there is an out-of-balance status for 3 consecutive days between Postal One and the general ledger. The postmaster unit manager or designated employee must research and resolve the out-of-balance master trust accounts upon receipt of the narrowcast master trust exception report. You have to give them a directive that there's an out-of-balance account with the general ledger, and you don't have to use the electronic site to do so. The Social Security Administration is going to be evidence of that very thing. Just so everybody sees what I'm reading from, Handbook F101. This was the basis of, like I said, that 43 video series that I did on reconciling master trust accounts. Everybody's got this broadcast view of everything, when there's actually a narrowcast that you need to think about. And that narrowcast, when it comes to narrowcasting, it's you're casting your net specifically to one spot. That's that state's vital statistics jurisdiction. It is exclusive to one person. So let's look at the next thing. When it comes to that investment and trying to reconcile all of this stuff, yeah, you can go get a job and make money to go buy a piece of land. But in that process, you're still going to have records that are messed up that you're going to have to correct. No matter how you look at it, you're going to have to correct their view of the record. You're going to have to bring supplemental principles of law to the record in equity through common law that acts in personam. So the only way to do that is through the contract. That's the in personam. The trust is involving the property, which is in rem. That's the state. So the state is holding the thing, the property, so they are the trustee in that situation. And in rem is where the principals go to get their equity. And they have to assert common law, and the common law is based on the supplemental principles of law because equity was merged with common law, that then the statutory law was then derived. It's uniform throughout all jurisdictions because it comes from equity. So when you invest, say 7 years, raising funds in that monetary system so that you can go buy land and then supposedly redeem it, what's the difference? And if there is, what's the balance? Is there a balance different? Is there a difference in the weight of the investment? If instead of going out there and working, you spend 7 years researching all this so you can show the path to redemption through their very own codes that are derived from scriptures. So I want to remind you, I've spent 7 years doing this research. And 7 years is a particular time span of time tracked. And that's that prodigal son that wasted his estate as a spendthrift. And he had to earn it all back so he could turn around and go back to his father. He had to spend 7 years in servitude, bonded servitude, voluntary bonded servitude to that which he invests that would return him to his father's estate. If your father's estate is truly about knowledge, then I urge you to invest in the knowledge. I believe it has more weight. So let's take a look at Deuteronomy 15 as it relates to the bankruptcy laws that they operate under. And it says specifically here, at the end of every 7 years thou shalt make a release. At the end of every 7 years thou shalt make a release. And this is the manner of the release. Every creditor that lendeth aught unto his neighbor shall release it. He shall not exact it of his neighbor or of his brother, because it is called the Lord's release. Of a foreigner thou mayest exact it again, but that which is thine brother, it is thine with thy brother, thine hand shall release. Thine hand shall release. What's your hand do? Is that the hand that you use to sign things? Isn't that supposed to be a release where you lend credit unto your brother? So do you suppose if you recognize your brother in that document as your brother, That's that equal consideration. That's the release of liabilities, the indemnification. Of a foreigner thou mayest exact it again. So do you suppose they're seeing you as a foreigner and exacting it of you again, and that all you have to do is correct the record? Hey, I'm not a foreigner. But that which is thine brother, thine hand shall release. So identify thine brother in that document. Qualify that signature. Next of kin. By benefactor. Some shit that will get them to understand you are not the foreigner. Save when there shall be no poor among you. For the Lord shall greatly bless thee in the land which the Lord thy God giveth thee for an inheritance to possess it. This goes to the redemption. In all of the lands of your possession, remember that. Only if thou carefully hearken unto the voice of the Lord thy God to observe to do all these commandments, which I command thee this day. He spake, and it was done. He commanded, and it stood fast. Listen to him. For the Lord thy God blesseth thee, as he promised thee. This is the original promise, and it acts just like credit. And thou shalt lend unto many nations. It doesn't say lend anything but credit. So what did Caesar really lend you if he put his face on the property that belongs to God, which he created? All he did was reform it and put his image and likeness on there in person. But thou shalt open, if there be any among you a poor man of one of thy brethren within any of thy gates in thy land, which the Lord thy God giveth thee, thou shalt not harden thine heart, nor shut thine hand from thy poor brother. Again, this goes to the knowledge. And if I've got the coin, if I've got the gold, I know damn well where it comes from, and I can help you express that in your contracts with a gold clause. Senate document number 43, contracts payable in gold, the history of money banking. But thou shalt open thine hand wide unto him, and shalt surely lend him sufficient for his need in that which he wanteth. There's currently a deficiency in the record. It's showing a debt. That's a deficiency, proving that there is something going on with the efficiency that means it could be more efficient. Beware that there be not a thought in thy wicked heart, saying, the 7th year, the year of release, is at hand, and thine eye be evil against thy poor brother, and thou givest him not, and he cry unto Lord against thee, and it be sin unto thee. So when your brother comes asking for credit, you're supposed to give it to him. Otherwise, it's going to be a sin unto you. See, they're the ones playing this, and thou givest him not. See, there's supposed to be equal consideration. So if you give your brother something, even if it's the nation that's giving you something, you're supposed to come back with something in equal exchange. If the nation has promised you full faith and credit, then give them full faith and credit from its source, the full armor of God, and he gave the first promise and sealed the first promise with the first oath. Thou shalt surely give him, and thine heart shall not be grieved when thou givest unto him, because for this thing the Lord thy God shall bless thee in all thy works. Going forth with that kind heart and expressing the credit side of things instead of acting like a debtor all the time and not knowing that you do have the value to put into it. You just think the value is coming from the gold or the paper money. You're not operating in the full faith and credit like David did against Goliath. Again, it's a Goliath beast, and you are David. Put on the full armor of God, shedding off the national armor, because you are a prophet unto the nations, and the only prophet you need to make is the correction of the record for its deficiency. For the poor shall never cease out of the land. Therefore I command thee, saying, Thou shalt open thine hand wide unto thy brother, to thy poor, and to thy needy in thy land. If any thy brother, or if thy brother, an Hebrew man or a Hebrew woman be sold unto thee, and serve thee 6 years, then the 7th year thou shalt let him go free from thee. And when thou sendest him out free from thee, thou shalt not let him go away empty. So when you have a record where you've paid into it for 35, 40 years under an employment scheme, placating insurances are required, and you have to register this and apply for that and sign all these documents, you have a way to recoup those credits, redeem those credits that are already there and have never been used. They have never returned back to source. So I don't care what anybody says about the way I'm doing things and whether I'm truly investing in that system in a proper manner because I'm doing paperwork as opposed to going out and getting a job or doing something on YouTube and then call me a grifter and a fraud. It's pathetic. So let's look at some interesting information next to help throw some things together for you. And I hope I don't confuse you with too much, because when it comes to that certain piece of real estate, I urge everybody to reconsider and think that maybe you're a little bit off and you're acting like some fucking fish, hook, line, and sinker. And if you think I'm playing games with the words, you better play again, because this is directly from the horse's mouth again. I want everybody to understand how this agricultural system works and the gross domestic product and how that tax has already been paid and it sits in the IMF as a credit already. So let's take a look at 7 U.S.C. Subchapter 1, Subchapter I, Real Estate Loans. Persons eligible for real estate loans and purposes of loans are the only things I'm going to talk about here tonight. But before we get into that, I want everybody to notice this starts out with Section 1922 instead of 1921. But when we find 1921, it's congressional findings. And it simply says, the Congress finds that the statutory authority of the Secretary of Agriculture, reminding you that implementing a statute or executive order is a contract, requires contract terms and conditions in order to implement for commercial items, commercial services. So that statutory authority is a contract between Congress, who shall lay and collect taxes, duties, imposts, and excises, and the Secretary of Agriculture, hereinafter referred to in this chapter as the Secretary, for making and insuring loans to farmers and ranchers that should be revised and consolidated to provide for more effective credit services to farmers. The interesting thing here, folks, is you see this is blue line highlighted. Says there's a specific definition. Okay? So we're going to take a look at that definition, but first let's get back to our subchapter I, real estate loans. Because this is persons eligible for real estate loans, which is based on congressional records and credit services to farmers for real estate loans under this chapter. Persons eligible for real estate loans in general and not particularly or specifically. So it covers the general population. The Secretary may make and insure loans under this subchapter. Under this subchapter, which is a credit service to farmers and ranchers in the United States. So first and foremost, we're talking about in the United States, which I've explained many times is merely a record, because the United States is known as a debtor for United States vessels in special maritime territorial jurisdiction, which applies to the general public as an overlay jurisdiction, an imaginary jurisdiction, created and committed to through the paperwork. That's it. Therefore, the United States as a debtor is merely the record. And it's a debtor because it's deficient. That's what makes it a debt. It's deficient. It's got a lot of contract terms and conditions, but very few supplemental principles of law instituting the courts of law and equity. Nobody ever wants to talk about those. And to farm cooperatives and private domestic corporations, partnerships, joint operations, trusts, limited liability companies, and other such legal entities, meaning commercial entities, as the Secretary considers appropriate for that par value or that security interest, that are controlled by farmers and ranchers and engaged primarily and directly. Notice these terms I'm using. I'm talking about the principal, the primary creditor, the primary interest, and directives, instructions, in farming or ranching in the United States, subject to the conditions specified in this section. So one of the conditions is contract terms and conditions is farmers. What happens when we click on farmers, guys? From 7 U.S.C. 1991 A1, farmer, as defined, farmer, the term farmer includes a person who is engaged. That's a person. So it's not yourself, it's the person, the represented person who is engaged in, does that sound like a wedlock, a wedding, a marriage, a contract, engaged in, or who, with the assistance afforded under this chapter, intends. Intends. You always have to have that statement of intent, that letter of instruction, that letter of credit, that you intend that what you put out comes back to you. Intends to engage in fish farming. You're reading that correct, folks. A farmer is one that intends to engage in fish farming. The term farmer includes a person who is engaged in, or who, with the assistance afforded under this chapter, intends to engage in fish farming. And that has to be done in the United States. It has to be done in the record. If it's not there, then that real estate loan record is deficient. It is in debt. It needs something supplemented to it. What do you supplement to it? You supplement credit to it. What is credit? It's a release of liability. Farming as a verb. 17 U.S.C. 1991A2. Farming shall be deemed to include fish farming, nothing else. Shall be deemed to include fish farming, and it doesn't mention anything else, so it excludes everything else. Interesting how that works, huh? Another interesting one, as it relates to 7 U.S.C. 1, or 17 U.S.C. 1991 A9, the term direct loan means a loan made or insured from funds in the account created by Section 1929 of this title. Section 1929, Agricultural Credit Insurance Fund. Everything is a agricultural insurance. That is where the credits come from. In everything that goes forth in a gross domestic product, it has to come from a mineral or something of the land, from the agriculture, whether it be from timber rights, from mining rights, from crop and agricultural rights, whatever. Those are agricultural. It's given credit through the insurance fund. Surprisingly enough, it's because the acquisition by condemnation. Acquisition by condemnation. Through urban development, they can only acquisition the land by condemning it of its natural use so that they can put concrete slabs and conservation easements for commercial purposes. In that, they have to ensure that they won't condemn it so much that it will never be usable again. It has to be able to return to the credit of which it was first designed to be used for by the creator. Who the fuck gives anybody any right to condemn that which belongs to him? Article 1, Section 8, Clause 17, needful places and buildings, of which they extend the postal roads, And every last one of those buildings and the postal roads, as well as your country roads that are not paved, are all acquisitions or condemnations of the land for its natural use by the very material fact evidence that there is a road on there that is not natural. It is not a mere path. It is a road designed to extend the maritime contracts inland as far as possible, as far as need be. An officer of the federal government authorized to acquire through federal acquisitions regulations, which must have contract terms and conditions to implement statutes or executive orders hyphen commercial items, commercial services. Real estate for the erection of public buildings or for other public uses. Article 1, Section 8, Clause 17, needful places in the buildings. For Article 1, Section 8, Clause 14, persons. For Article 1, Section 8, Clause 3, commercial activities. For Article 1, Section 8, Clause 1, authorization by Congress on and between Article 1, Section 8, Clause 7, postal roads, and Article 17, needful places and buildings. And every one of those has a postal address on them. That's the Postal Service or Postal Realty Trust, Inc. They're the ones with the Real Estate Investment Trust. They're the ones backing all of this insurance with the Real Estate Investment Trust. They're the contractors that allow for the construction sites and construction contracts to overtake that natural land and then provide an environmental protection easement for that said address. It is a federal acquisition to implement federal executive orders or state statutory codes as contracts. You're not part of it. For the government, by condemnation, under judicial process, when the officer believes that it is necessary or advantageous to the government to do so. Where is the interest of the public? Is the public the government? They will say no, but we're doing it in the interest, or that's necessary and advantageous to the government. Is it advantageous to the government? I want to ask everybody, is it advantageous to the government to disillusion its people merely so that the government could maintain that control through not allowing you or through giving you a quote public education system that supposedly teaches you things when it doesn't at all? The only thing you learned from that is to remember certain things that they instructed you to do. So let's take a look again. As we come up on one of my favorite verses in Scripture, Leviticus 25, verses 23 through 25, as it relates to that person, that unambiguous signature on the instrument, therefore not liable for the person named in the instrument. And that instrument is the liability, and you have to be able to redeem the unnecessary or redeem the deficiencies. The land shall not be sold forever, for the land is mine. So what is all those documents about? For ye are strangers and sojourners with me. So why are you identifying as a permanent or temporary resident, someone that owes an allegiance to that king? And in all of the lands of your possession, ye shall grant a redemption for the land. Redemption equaling the indemnification. That's that government immunities in equal exchange for foreign sovereign immunities, because I am a sojourner with the sovereign. And I am foreign to the corporation, but I am allowing a forbearance to stand in full faith and credit. And that forbearance was the establishment of the legal name as a representation. There was no natural bearing of where it came from. I'm here to correct that. And in all the land of your possession ye shall grant a redemption for the land. And if thy brother be waxen poor, and hath sold away some of his possession, that name is part of your possession. It just isn't qualified properly. It's presumed to be the possession of a trustee because that's the way it was presented in the capacity of a trustee. All you got to do is change the capacity by understanding or knowing thyself. And if any of his kin come to redeem it, then shall he redeem that which his brother sold. Who is a closer kin to Keith Little? Keith Little himself, or maybe Kevin Little, or even Mary Little, who is truly the closest relative or next of kin. Because when it comes to Keith Little, the legal name, the closest relative would be the guy with the given name and family name that matches closest. And that would be oneself. So as I've said, it's a matter of knowing how to invest in what you have before you. And if they're going to offer you to do some intellectual work, that's one of the things I hope to be a huge proponent in showing people how to minister these documents in the correct capacity when they're offered. Because sometimes you can't act just like me and just quit all the jobs and the banking and then just start writing private letters and practicing that way. Sometimes you're caught up with a family and 3 kids and 2 cars and a nice $1.5 million home and a nice job that you've had for 25 fucking years and got a lot of equity built up in the home. And you can't just drop it and say, fuck it, I'm not going to do any paperwork. I'm just going to go build my own property. It's kind of hard to do that. So there are solutions along the way that will help clear up the record here and there, removing the deficiencies that exist all over the place. In doing so, it helps educate others on those same deficiencies that they too can correct and take upon a supplemental greater benefit. And yeah, some of them may not be as convenient, but provide a greater benefit. Others, some might not see the greater benefit and take upon the convenience as if though that's a bigger benefit. That's fine. You can have a driver's license and get a job with Uber Eats and use that to buy your property and leave that title in the name of the state and build your own property. But when it comes to your death, are you going to leave a living will that's going to be able to appropriately transfer that property so it can be used appropriately as you naturally intended? Or maybe you are going to go ahead and build a business on it. Maybe an automotive shop. But even then, are you going to hand that business back to the state by not creating a living will? Or are you going to make a living will and pass that estate on to your son so he doesn't have to go out and become an indentured slave and work for somebody else for 7 years so he can return prodigal son to his natural estate. See, that's the problem. Everybody thinks there's only one way to do it, but there's not. There's many ways to do it, and it's just a matter of recognizing what it is that you're trying to get to in the end. Do you really want the materialistic gains? If that's so, you can imbue that into your next generation and tell them to go for that commercial wealth through an automotive repair shop, but make sure that you do it so that they can keep it. That should be at least a minimum. That takes a matter of comprehension of how these trusts and the forwarding and transferring works. It seems reasonable to me to learn how it works so that if you don't want to use it, you can rebut it appropriately. Or if you do see something that is to your benefit, then you can use it to your benefit instead of just signing blindly. So as it goes to this information and its actual use, like I said, I'm on 7 years. And so hopefully got my I've already got my companion's birth certificate and statement of live birth and the receipts and all that. And I'm waiting on mine from the state of Iowa now, as well as the DBA. A lot of people do the Minnesota DBA. I think it's like $50 or something like that, and then you got to renew it for $25 every year or something. I don't know. Iowa, it's called a fictitious name registration, and it's $5. $5 to renew it every year. And all it is a statement saying good standing. This legal entity is registered, and it is registered in good standing. That's all it is. So you're providing a standing, and you're providing a security instrument that already has an original issue that can be discounted. And you can do it through a letter of instruction to the right trustee by doing the proper research. So when it comes to things like getting a purchase order for a car from a dealership, and you qualify your capacity properly, and you give them a directive through the instructions that you're the principal, and on this agent instrument, you're giving the directives for the credit extension to make a special deposit upon which that financial institution has already given credit or is obligated to give credit. And again, like I said, if I've already worked my ass off for 40 years, there are credits there. There's got to be. So all I got to do is redeem those credits for it. That's unearned income and insurance credits, all collected and established through the Social Security Administration. And you can get a statement from the Social Security Administration called the decedent numinant that will show all of those debts, all of those deficiencies. Now you can perfect the record by removing the deficiencies. Or excuse me, you can correct the record by noting the capacities were done in error. It was a mistake, which is the allowance for equity mistake. Well, let's go back and fix it. Okay, so when we go back and fix it, we find the inconsistencies, and that's those deficiencies. And every one you find that has to be corrected, it either has to be corrected in the capacity of which it was signed for, or it has to be able to, it creates an impossibility, and there must be another remedy creatable for it. Because if it's just an inconsistency and can be corrected in that capacity, then you have to start at that point and sign as a trustee. But if you're not, in fact, a trustee, you weren't qualified to sign as a trustee, and that blank endorsement presumed to be a trustee is not qualified. Would we want to notice appointment acknowledge these trustee before letter of instruction? You're going to acknowledge the trustee in the letter of instruction. You're going to get the trustee through the securities filings. 4.1, it's going to tell you who the trustee is. And that's who you address it to and send it to them. They're the ones that are already assigned. Like I said, this stuff's already done. You've just been signing in the wrong capacity. Everything is, the letter of instruction is just pointing out that you're truly the creditor. Therefore, it acts the same way, performs the same way as a letter of credit, a directive. I'm the guy it's coming from, and if I put it out, my yay is my yay, and my nay be nay. Anything I put out as credit has to come back to me as credit. That's all I can give is credit, and I'm just a pass through. The real credit comes from him. So in order for me to operate as or conduct my affairs as that pass through, I have to recognize that I'm just a pass through for that person that they're using. It's a usufruct. They gave me a person to use, but I'm just a pass through, and the only capacity I can use that in is by clarifying the signature in a proper qualified manner. Benefactor, and that's it. Otherwise, the presumption sits that I'm a trustee and I can only transfer the property and I don't own it. It doesn't belong to me. Therefore, anybody can come along and take it, and that bearer of security belongs to them. Now they can enforce it. And if it's got my name on it, they can enforce it against me. That's how they get away with taking your damn automobiles. They've got a title. They're a holder of an instrument, and they can enforce it. You're a holder of an instrument, you can enforce it too if you know the proper assignments aren't there and can't be made. Reissue, reissue, bearer form, reissue. Let's look at that again. For presentation to the United States. For presentation to the United States Treasury for redemption or in exchange for securities of a new issue in accordance with written instructions submitted by. This line here is to be filled out by that trustee. This is showing that the Treasury is the principal for that trustee. He's got to listen to what he was allowed to do. He was designated. The secretary was designated by the Secretary of Treasury. Secretary this, Secretary that. They're all designated, and then they pass on those designations to the trustees. Everybody is a trustee by presumption. If you're handling that document that they created, they issued as a principal, then you act as a trustee on that document by not qualifying that signature. You're going to be treated as a trustee, and they're going to be treated as the beneficiary because you never made that qualification. Now, they are holder in due course because they have it. They're holding it, and they are bearing it, and all they got to do is qualify that they're the beneficiary. Oh, okay. So we got to remember this stuff and understand that the words are very important, and it is a key to deciphering. I will call it deciphering their forms because, like I've said before, folks, the English language is beautiful once you understand how simple you can make this stuff. So back to the issue about the car purchase order. You qualify that purchase order. Guess what? It's a 3-day turnaround generally. That's what that master trust account is all about. That's what you're doing with the purchase order in this qualification is letting it being directed to the general ledger. The Postal Realty Trust Inc. is a real estate investment trust that's attached directly to that general ledger. And by using that address in that capacity, you're again operating as a presumed trustee. This is why I say when you address me on those forms, it's Brother Keith in Ecclesia, full colon stop. Notice there's no last name. Care of Joyce, full colon stop. Notice there's no last name. Guess what? That's not a legal shipment. It doesn't have a last name. The legal name consists of a first name and last name. If you're only using what they see as a first name, then it can only be cognized as a given name. So then you put the street number, which is its bonding number, and the street name, which is a street name securitized, and the evidence is material and factual on the face of the use. It's got a street name that the municipality created, and the Postal Service attached a number to it. That's evidence of a contract. And then you have the expression of a trust. City, state, zip. Postal Service operating the zip, and now you got the state in there. That's three parties. That's the expression of a trust. The municipality is the beneficiary, and they have swapped you as the trustee because you keep claiming resident, United States citizen. That's an internationally protected person. So not only are they violating the American citizen that doesn't know how to express it, but they're violating an internationally protected person that was conferred to him as a nationality, a gift, upon enumeration at birth, so that he could perform in this credit system to his benefit. But now everybody's dismissing the interest of the United States and the principal because they're claiming the interest of the beneficiary and saying, nah, and using that signature as the reason. Understand that if you're going to sign anything, you better know how to qualify it. If you're going to be stubborn and not sign anything, you better be good at giving oral directives so that your yay is your yay and your nay is your nay. You better be able to give the qualified distinctions of, listen, if you want me to sign on that instrument as the authorized representative of the, or a representative for the represented person, then you got to accept the terms and conditions you put in there that I get to sign in that capacity by qualifying it, what capacity I'm not liable for, to release your liabilities in the equal consideration thereof. To me, it's all simple language now. And I probably could do it orally. Never perfect, but I know I can always go back, review it, and say, oh, that's the mistake. I've got most of it up here now. I don't need all this stuff that I'm showing you guys. But what I am showing you is there's many ways to do different things. I've showed how to abate communications from a court trying to collect on something by putting it right on the envelope, sending it right back to them, and shoving all the codes right down their throat, proving that if they move on this issue, and I find out you come after my companion's account and remove thousands of dollars, you're going to be caught up in a securities fraud because I'm going to do a forensic securities audit on it, showing you that that obligor number that you used is a conversion of the Social Security number that she's always used, and that proves somebody else committed a conversion that she didn't know of. Now that she knows of, and it leads to other information as to qualifying that signature and the capacity of that obligation and not coming back to the credit source, yeah, we're going to fix a lot of things. So when I do that, 6 years ago I did that. That was when she was living over on in some apartment in some court, some crackhead area, and she got a letter from the clerk of courts. So I abated it myself and sent it back, and they've never written to her again about it. It's been 6 years. The medical associates that said that they weren't going to provide her services anymore, even though she's disabled and worked for this fucking country for 35 years as a public education teacher, retired, no longer responsible or obligated for performance of functions of public office. She's to receive her benefit. Her period of contracting is over. Now she gets to receive the benefit, and they're making threats that she's not going to receive the benefit that she's due and owing. So I asked them for a true bill. They sent me what they said was a true bill, not one plus sign on it, very few minus signs, and no sum total of anything anywhere, particularly or specifically not even a dollar sign or the mention of dollar on there, or credit or debt. So it was basically an impossible mathematical equation, which is what I told them. To us, it looks like a mathematical impossibility. I don't know what you're looking for here. I see zero value. That was 3 years ago. And I've showed the writings on both of these. Got pictures of the envelope that I sent back 6 years ago. It's in my on my Facebook page. I've showed that many times. Same with the letter that I wrote to the local medical associates. I made a post of it, copy pasted it, verbatim. These things are things that work. But again, they're only temporary. They don't actually fix the actual record. They only fix the concept in the people's mind that we're dealing with directly. So when it comes to that probated record, it still needs to be corrected. And that's all we're trying to do. Correct that record so that the credit can flow. It truly is a credit system. And if you're going to give unto Caesar what belongs to Caesar and give unto the Father what belongs to the Father, then you accept what comes from the Father. And let Caesar know that you can accept what comes from Caesar, but it's got to ride on the credit that's already there. It's got a supplemental credit. It's got a supplemental value that is greater than what you're offering here. But that doesn't mean I'm going to take away from Caesar. I'm going to let Caesar have what's due him too. He's due a benefit. That's how much power you have, is recognizing just merely where the credit comes from and sending it back. Everybody's going to have to recognize it. They all believe there's a greater creator. They all believe that's where credit comes from, is something else. Unless, of course, we're talking about the egotistical guys that, oh yeah, I created this and I created that, and they're still acting that person. They go buy all the licenses and insurance and all that. Those are heathens. Those are ones that are bonded in servitude voluntarily for persons, and he's no respecter of persons. So why would I respect them? I can respect the documents they put forth by putting greater truths into them. That way, if they are workable, I can accept them conditionally. And if the conditions aren't favorable, then I can't accept them. And that's the funny thing about their public accommodation. When they make an offer, there is honor among thieves. All you have to do is make sure that the vote for you is in there. That's that parlay. You have to make sure that while casting a vote to see who is going to captain the vessel, you're going to captain the vessel, and you're going to show how it's supposed to go out and come back. It's just like a travel plan. You got to have some kind of travel plan. Your intent. Oh, I just plan on traveling the world. Well, yeah, you can do that. But that's just pointing out A to B. What are your actions going to do with the people and everything that you interact with at point A and point B and all points along that path? Because anywhere along that path that somebody reaches out and takes that credit, it's going to slow down your vessel. And that's what's happening. They're slowing down your vessel so it comes to a complete dead stop. Dead. So anyway, think about this stuff, and hopefully I'll be back soon. I'm going to be back tomorrow night with the pop stuff, going back to the post office protocols. But in regards to coming back soon, that I'm talking about here, like I said, I got the birth certificates and everything ordered, and we're going to be working on some purchase orders. I've already, like I said, in the Saturday morning class that I've been doing for a couple of years, Steve Martin's in there now and finds it excellent information. It's helping him out and all kinds of things that we're finding as resolutions in a trust form. Knowing the contracts and knowing how to position ourselves in those trust forms as outside of the contract, but the benefactors, the ones that the property actually belongs to. So again, hopefully I'll be back soon with some results on that as far as being able to qualify certain bills, giving them directives, letters of instruction to the trustees so that the credit can go through by making a special deposit in a financial institution that is given credit or is obligated to credit if they haven't already done so. And that is a primary obligation because we are the primary creditor. There's a primary creditor on one side, and the opposing dynamic is a primary debtor, primary obligor, a primary obligation to a primary intent. And with that, one last reminder, hit that like, share, and subscribe button. Of course, there's a PayPal button down below for anybody that wants to share some love. And like I said, I certainly appreciate it because I haven't been able to affect everything to my will or my wishes. There are still things that I need. But again, just because I'm not out there working and providing an income into the house doesn't mean I'm affecting an investment in an opposing dynamic where I'm being able to dismiss certain charges that shouldn't apply. So instead of paying the 15 different medical associates that $14,000 or whatever, it gets dismissed because it's zero value in the way they presented it. So anyway, hopefully I'll be able to show you guys soon how to present things in a different way of investing so that you don't have to go out there, be some goddamn hermit trying to live off the land and build your house without any kind of monetary instrumentalities or having to work for 7 years to get up all the money or gold or whatever you're going to use to purchase that land when you can't purchase the land anyway. You're supposed to be redeeming. Redeeming meaning buy back. So if I sold off the property into the system, I should be able to buy it back. How do you buy it back? By use and possession for its natural possession and use. It's already protected for that, not commercial use. So again, hit those buttons and remember, I love you, but I don't give a rat's ass whether you love me back. And that's to say, I don't care if you hate me. Hopefully one day you'll learn how to be the redeemer because you're already redeemed. It's already done. The trust is already there. Just learn how to recognize it and separate it from the fictional trust. And with that, may God bless you and have a good night.